Hello everyone. Today I want to lay for you something cool, you guys. This is something you ought to know, something you ought to understand. And this is the doctrine of precedent. This is something for your importance, ranging from the legal scholars and to the public. For the public, the day you go to court and they use it on you, that's when you start regretting. How I wish I knew it. So the doctrine of precedent. Briefly, I'm going to give you some layout, some principles, some facts about it, and maybe some case law, if any. The doctrine of precedent, several legal sources have come up with different definitions. But for me, in my evaluation, I found out that they mean almost the same thing. So, I opted to use the Black's Law Dictionary. The Black's Law Dictionary takes the doctrine of precedent to mean a decided case furnishing a basis for determining later cases with similar facts or issues. Simply, this doctrine dictates that a court should follow decisions made by higher courts or superior courts in cases of similar material facts or issues. This simply means that a subordinate court must follow a decision that was made by a superior court if the decision arose from a case which had similar facts with it. Kidu Makubia, this one is a legal author in Uganda, opines that in court system, a court that is lower in hierarchy should follow a decision which has got the similar material facts with the case at hand, just the same way as it was already decided. For the case of Uganda, Article 129 of our Constitution simply stipulates the court hierarchy. It states the Supreme Court as the highest court, Court of Appeal, and then the High Court and other subordinate courts. Simply in that hierarchy, a decision made by a Supreme Court is bound to the Supreme Court and to the High Court in general. So they ought to follow everything, and that's what we call the binding precedent. This doctrine of precedent gets its roots from the doctrine of stare decisis. Doctrine stare decisis. This is a Latin word to mean stand by which was decided. So this means that once a principle or a law has been settled by a court, a Supreme Court, it's no longer open to any judgment or any new ruling or any examination by binding courts, simply because a precedent has already been set. So the doctrine of stare decisis simply brings out the basis or the roots to the operation of the doctrine of precedent. In this case, the judges ought to follow certain instances. There is an exception in this, and that is in the Ugandan Constitution, Article 132, Clause 4, I think Clause 4. It simply states that a Supreme Court can depart from its previous decisions while treating, okay, it says, I've forgotten the way it flows, but while treating its previous cases as normally binding, it may depart at some time, and other courts are obligated to change and bind to the new decision made. And that is similar to Justice Kanyamba. He was once a justice in the Supreme Court, simply stated something about it in the Paul case, Mogere case, and others versus Uganda. It's a 2005 case. But in the next video, I'm going to give you some case law about this. I just want to lay some principles of the doctrine of precedent. There's another important note about the doctrine of precedent, and that is the ratio decidendi. The ratio decidendi is a Latin word that means the reason for, or the rationale for the judgment. You can say that this is a point in a case that sets out the judgment. So the judges pay critical attention to the ratio decidendi of any case when using the doctrine of precedent. And this is the case. This is the time that judges examine the case they want to use to lay a basis for determining a case at hand. Simply, in summary, you're going to say there's a ratio decidendi that gives a root to the use of the doctrine of precedent. And the doctrine of precedent, judges are meant to follow the doctrine of precedent basing on the doctrine of stare decisis. That's the brief summary. Ratio decidendi, the precedent up, and then what obligates them to use the doctrine of precedence, the doctrine of stare decisis, to stand by which was decided simply. So all in all, the public and the legal scholars ought to know these words, and they ought to know that the doctrine of precedent comes into action from the doctrine of stare decisis. And then the judges pay critical attention to the ratio disdain. It's for every person's good to the public to get to know certain things about the law. Simply, the doctrine of precedence has gotten several advantages to the judicial system. One, it saves time and it plays consistency. And me, I take this as more important. It makes the public get more faith into the judicial system simply because they at times get to know what the judge is going to decide based on the previous case. Simply that plays out. Hello guys, in the next video I want to bring out some case law about it. Thank you.